had a line prosecutor who wanted to file charges. Her bosses, though, up the chain of command, they all believed that the case was too weak to charge based on one victim, and they all believed that there were likely more victims out there. That was a premise from very early on, that this was not a single incident involving victim one, but that Sandusky hadn't fit the profile of somebody who was likely to have offended on many occasions with many victims.
But it was a calculated risk, not one that you really easily want to take.
So what happened in 2010, the decision, again, reasonable minds can differ about that decision whether to charge or not, but during the time that that they were considering the decision and for several months thereafter, there really was no concerted effort to go find more victims, and that's puzzling in retrospect.
I think you all need to understand how investigations work. You get information, you get a case referred to you, you begin to take a look at a case, and you develop witnesses. Harold, you know this. You develop witnesses, and you go from one witness to the next, and you continue to build a case. Oftentimes it leads you to places you never would have imagined that it would lead you to. So, I mean, oftentimes it takes quite a bit of time.
Okay, why did the Sandusky investigation take as long as it did? That's what the Attorney General said. That was that's the central question. All the questions sort of revolve around that question. Failure to take certain steps earlier in the investigation that proved very valuable later on. Okay, what were those steps? The most significant of those steps, any one of which could have been taken in 2009 or 2010, were searching Sandusky's home, asking the local police about earlier investigations involving Sandusky. That's how they ended up getting the 1998 allegations or finding out about them, and questioning the local Children and Youth Service and the Second Mile about Sandusky as well. And again, the report talks about all those decisions. I want to spend a minute or two now, though, on the subject of the search, because this is really, I think, an area where there's an important lesson to be learned, I hope. As one expert put it in a book written before Sandusky was charged, I'm going to quote, "The major law enforcement problem with the use of search warrants in child sexual victimization cases is that they are not obtained soon enough." Again, that's not written about Sandusky. That's written generally about these sorts of cases. Read that again. "The major law enforcement problem with the use of search warrants in child sexual victimization cases is that they are not obtained soon enough." And that was certainly the case in the Sandusky investigation. The search of Sandusky's residence did not occur until June 2011. Right? That's more than 2 years after the case got to the Office of Attorney General, and as you'll see from the report, it's more than 18 months after searching was suggested by an investigator in the case. Again, more than 2 years after the case came in, more than 18 months after an investigator suggested conducting the search. And when the search finally did happen, it uncovered unquestionably valuable evidence, including photographs of Sandusky victims and lists of Second Mile campers with asterisks next to some of their names, asterisks that later turned out to line up with people that Sandusky had victimized. Had the search been conducted in 2009 or 2010, investigators could have used those photographs and could have used the names to find victims much earlier than they did. Now, why did the search not happen earlier? There are a number of reasons given, one of which was to keep the investigation secret. Another was a concern about the lack of probable cause or staleness. But the experts tell us that serial child molesters regularly maintain, in terms of staleness, which is the idea that months after a crime has occurred, it may be less likely that evidence of that crime is going to still exist at the location in question. So was it likely? And victim one's, I knew I was going to do that. Victim one's allegations were about conduct that ended in the fall of 2008. Right? The case doesn't come to the Office of Attorney General until March of 2009. So a number of months have passed. Is it now too late to conduct a search? Is the evidence stale? And the answer to that is no. The simple answer to that is no. And in fact, the evidence was not much fresher in 2011 than it was back in 2009. And that's because experts tell us that serial child molesters regularly maintain valuable evidence about their crimes, including items as simple as ordinary photographs of their victims, which is something that Sandusky did. Moreover, victim one described being abused in Sandusky's basement at his home and provided investigators with valuable and significant details about the layout of the home. If for no other reason, a search early on could have provided very useful corroboration for victim one's story, which is exactly what some people were saying they needed before they could charge, and yet the search didn't happen. Based on some of the responses to this report, some of the people involved apparently still think that they did not have probable cause back in 2009 or that the evidence was too stale. I completely disagree with that. Search warrants are properly issued every day based on the word of a single victim. If the idea that a single victim wasn't enough to get probable cause, that would be astonishing. Right? It's one thing to say that a single victim might not be enough to support a conviction. Right? Again, we talked about that. That's something that reasonable minds might differ about. But it is quite another thing, I think quite wrong, to suggest that it's not enough for a search.